Good afternoon, and welcome to the Employer Link webinar series presented by McAfee Taft. My name is Brad Neese, Managing Editor of Employer Link. Today our focus is on the changing of the seasons. Spring has sprung, which means the retirement plan audit season is just around the corner. And for some employers, an official Department of Labor investigation may be in the forecast as well. Our presenters today will give you an inside peek into the audit process, review the steps you need to take now to avoid common errors and prepare for the audit, and discuss why your selection of a qualified auditor really does matter. They'll also take a look at why DOL investigations of health plans are on the rise and what you can do to put your company in the best position to stand up to the agency's scrutiny. Our presenters today are Brandon Long and Bill Freudenrich, ERISA attorneys who work extensively in the area of retirement plan design, implementation, and compliance, and who routinely represent clients in audits and investigations by the IRS and U.S. Department of Labor. They are joined by our very special guest, Gwen Bryant, assurance partner and ERISA leader with the accounting firm of HoganTaylor. Gwen is here to lend her expert insight into the audit process and the selection of an independent qualified public accountant. So with those introductions, I now turn it over to you, Brandon.
Hi there, and thanks so much for joining us again for another webinar. This topic is DOL audits with the chance of investigations, and really it's kind of, we're trying to talk about or communicate some of the things that we've seen recently with respect to the DOL's activities. Part of this will focus on the kind of the requirements for audits, who's required to have an audit in terms of retirement and health plans, and then assuming you're subject to the audit requirement, what are the auditors looking for? And audit season starts here in about a month, in the month of May. So we thought this topic was timely. And then we've unfortunately, we've had some situations this year where we've had some deficient audits. And so if you pick an auditor that doesn't know what they're doing to audit, for example, your health plan, what are the consequences to you of picking someone who's not, who doesn't know what they're doing? And then Bill has had, in the last 2 or 3 weeks, literally the last 2 or 3 weeks, multiple DOL investigations. And so the discussion Bill is going to cover is very much hot off the press in terms of what is the DOL looking for, what kinds of things should you be thinking about in the event that you're one of the lucky winners that gets the DOL showing up at your doorstep to do an investigation. I'd kind of like to start with a little bit of kind of shock value, if you will. I'm sitting here looking at a report that says in 2014, the Department of Labor's Employee Benefits Security Administration, which is the arm of the DOL that looks at benefit plans, indicted 106 individuals for offenses related to employee benefit plans. 106 individuals were indicted for criminal wrongdoing with respect to benefit plans. And I know from the folks that are on this call, none of us are trying to do anything evil or wrong, but people out there are doing bad things, and the Department of Labor finds them. And so a lot of the time, the things that seem very annoying to us are designed to try to pick up things that are really happening that are bad and should not be going on. Also, in 2014, I think this is interesting, the Department of Labor recovered $599 million in payments for, to retirement plans for money that was owed to the plans or to plan participants. So we had in 2014, just this last year alone, 106 people indicted, almost $600 million in penalties, civil penalties recovered by the Department of Labor. So all of this is very important because we don't want any of you to have to worry about any of that. Okay, we're going to start with, in terms of retirement plan audits, which retirement plans are required to have an audit? For large retirement plans with 100 or more participants, generally, you should be having an audit every year, and that is conducted by an independent qualified public accountant. It's important to note in determining whether you're subject to this requirement, it's not just those who are actually in your plan, it's those who are eligible for the plan they are defined to be a participant as well. Health and welfare plans, generally speaking, most of our health and welfare plans are not subject to an audit requirement. And I say generally speaking, if you have a trust or you have money that is running through a trust or a kind of a set-aside bank account that's in the name of Gwen, the bank,
in the plan,
in the plan's name at a bank, you might be subject to an audit requirement. But generally speaking, like our health plan here, McAfee and Taft, we're a self-funded medical plan. We do not have an audit every year for our plan. All of our pre-tax money runs through our cafeteria plan, and so we're not required to have an audit. At the bottom of this slide, we wrote DOL inquiry. We're noticing that the Department of Labor is doing a lot of cross-checking. They're looking to see, they say, okay, XYZ company, you're filing a $5,500 for your 401k plan, but we don't see a $5,500 for a medical plan or a dental plan or vision. We've been talking about this topic for some time, but again, it's a nice reminder that it's important if you have if you're filing a $5,500 for your retirement plan and you are required, if you have more than 100 folks in your health plan or dental plan or vision plan for that matter, you should be filing a $5,500 for that benefit as well. I'm going to turn it over to Gwen. The reason we asked Gwen to join us today, we work with Gwen and the HoganTaylor folks quite a bit, Gwen knows what she's doing. She's someone that, again, with audit season about to start, she's going to tell us what does she look for, what do auditors look for when they show up to do an audit of your plan, what kind of common errors does she see, and she's going to talk about some of the DOL initiatives that have identified deficient auditors, frankly. So I'll turn it over to Gwen.
Thank you, Brandon. Whenever you hire an auditor to come and audit your plan, one of the first things you're going to get is a PBC list, which is basically provided by a client list. It's going to have a lot of information on there. And the auditor is going to be looking for that complete list before they ever start. And you may be wondering, why are they asking me for all this stuff? Some of the accounts maybe don't have large balances. What's important to understand related to an employee benefit plan audit is not only are you auditing certain balances, and that depends on whether you're doing a limited scope or full scope audit, and I'll explain a little more about that shortly, but also the DOL expects the auditors to test certain things related to compliance with the plan document. So there may be certain things in the plan that auditors of employee benefit plans have to test that really don't have anything to do with the numbers at all. So they're going to be looking for what are the procedures and processes over the administration of the plan, what are the checks and balances. With that, they're going to assess risk. Where's the plan at risk for fraud or misstatements or misappropriation? So again, like I said, compliance with the plan assets. But in regards to the financial statements audits themselves, an employee benefit plan auditor is going to give an opinion on whether or not they believe the financial statements are materially correct or not. But also, they should be providing you a management letter for recommendations or areas where you could improve or any deficiencies they see. So I want to talk a little bit about a limited scope audit. About 80% of employee benefit plan audits are limited scope. This statistic comes from the Department of Labor, and in that situation, either the trustee or the custodian that's holding the plan assets may issue a certification, in which case the auditor does not have to specifically test those assets that are certified. So basically, in that situation, the audit almost becomes like a compliance audit, that you're testing the plan document more so than the value of the assets themselves. On a full scope audit, you would test all the material balances as well as the compliance features. So looking at or trying to avoid some of the common mistakes auditors see as a whole is, I can't emphasize enough how many times we see errors where the plan is just not being administered according to the plan document. In the next year or two, there's going to be a lot of plan restatements, and a lot of times there's issues where a box didn't get checked when you restated your plan, and then you're operating the plan as you always have or the way you thought it was supposed to be, and that doesn't exactly align with the explicit terms within the plan document. The other issue we see a lot of times is not hiring qualified service providers, and more importantly, not monitoring those service providers. I believe we'll be talking a little bit more about some of those issues where sometimes you may have a service provider that says, let's get your 401k plan set up and we'll take care of everything. You don't have to do anything. And that's honestly not the case. You still have to monitor those service providers, and in certain situations there's documents you need to retain, and I think Bill will be speaking to that a little bit later. As far as fiduciary duties, this is something that the DOL is definitely honing in on. And hiring quality service providers is a fiduciary responsibility. And with other fiduciary duties that are not performed prudently, there are penalties associated with not performing those, and we'll talk about those a little bit more. Other mistakes we see relate to plan sponsors not really understanding that the investment options that they provide to participants, that they are ultimately responsible for the valuation, not only providing good investment options for your participants to select, but understanding how those are valued and whether or not they are, some are more hard to value than others. Another thing that you might want to be aware of is oftentimes auditors draft the financial statements for their clients, and this is, common practice except for any 11K filings. Auditors cannot even, help type in anything up related to a 11K audit. But non-11K audits, a lot of times auditors will help draft that. And according to auditing standards, there's some specific rules related to that where someone at the plan sponsor has to take responsibility for that non-attest service. And in 2015, that's going to be a lot more focused on by the Department of Labor. All right, so talking about some of the plan deficiencies that we see. And this list not only is what auditors see as a whole, but this list is very consistent with what the IRS and the Department of Labor also identify as common deficiencies. Incorrect use of the definition of compensation. We see this time and time again. It's an area that has to be corrected quite frequently. You may have 14 different definitions of compensation within your plan document, depending on how it is designed. You may have one definition for deferrals, another definition for match, another definition for testing, another definition if you have a profit-sharing allocation or something like that. So you can't assume that you understand the definition for one and apply it to all. So it's very important just to know what the plan document says related to all those definitions. Same thing with eligibility. You can have different requirements for different aspects of your plan, whether it be matching, deferral, contribution, profit-sharing contributions. The untimely deposits or late deposits, that is consistently an issue that the department finds. This is also one of the areas that if the Department of Labor or the IRS find during their investigations, they will share that information with the other regulatory agency. Bottom line is you want to get your participant deferrals and loan repayments remitted to the plan as soon as possible. If you can do it within a day or 2 days, that's really going to be the expectation.
Gwen, you might want to talk about the small employer who has the 7-day limitation.
Right. A small employer has a safe harbor that if they have less than 100 participants, they're considered a small plan. As long as they get the deferrals and loan repayments in within 7 business days, that is going to be considered timely. You do not have that for a large plan. There's not a safe harbor. The DOL is going to be looking for that to be remitted as soon as possible. The law typically says within the 15th business day of the following month. The DOL has said repeatedly that is not a safe harbor. They expect you to get it in as soon as possible. So another common error is related to amendments. Oftentimes what we see is plan sponsors rely on a third-party provider or someone else to make sure their plan is amended, that they're notified when an amendment is required. As I mentioned earlier, this is the time. A lot of the prototype plans are being restated now, so that's something that you probably will be seeing your provider have you update your plan documents. you want to make sure they're executed and properly approved. The improper allocation of employer contributions, that really relates to the definition of compensation. Those two kind of go hand in hand because oftentimes that allocation is going to be based on the definition of compensation for that allocation. So we actually have seen many issues related to this where perhaps the person has to be employed on the last day of the plan year to be eligible for that, or it's only the compensation from when they enter the plan, not their compensation for the whole year. So you definitely want to test that denominator, which is your total eligible compensation, before you perform that allocation and provide it to your TPA. Compliance testing issues. As auditors, the audit requirement is that we inquire as to whether or not these tests were performed. We typically do not recalculate the compliance test, but again, this goes to the definition of compensation. If the testing data that they're using is not correct, then the test is very likely going to give you a false result of whether or not you passed or not. So you definitely want to do reconciliations and make sure your compliance, the data you're giving to your TPA to perform that is correct. As far as vesting, most plans unless they're safe harbor, have a vesting schedule related to them. And typically, whoever's processing your distributions is going to be, calculating that. It's a good idea to test those yourself and look at those periodically. Where we typically see issues with vesting is when there's been significant layoffs and there may be a partial plan termination or something. In that situation, everyone who was affected by that partial plan termination would be 100% vested, and they may not be calculating that distribution correctly.
Gwen, can we take a minute to talk about what is a partial termination?
Mm-hmm.
We're seeing some downturn in the energy industry,
mm-hmm.
and any time you have involuntary terminations of at least 20% of your plan participants, the general rule is, even though it's based on facts and circumstances, those employees have to be 100% vested.
Mm-hmm.
Now, what's tricky is you don't take a snapshot at each layoff.
Right.
You generally take a window over 18 months. And that can be difficult because if you have forfeitures and you reallocate forfeitures to the remaining participants and you stack up 5 or 6 different layoffs over an 18-month period of time and determine that you've had a partial termination, you may have to go back and pull money out of a participant's account and reallocate that.
In most cases, you will look at most of the time we're looking at a partial termination issue. We are looking at a plan year to see if it occurred in a plan year basis. But what Bill is referring to of this 18-month, and really can be even longer period, is if you have a series of layoffs that are related, then they all have to go together when you run the calculations.
Yes, exactly. You almost look at it as an event if the layoffs are related to the same event. So moving on, hardship withdrawals, and actually, Brandon, you may want to speak to that here in a minute, but there are specific requirements of when you can obtain a hardship, and the language in your plan may be different. Sometimes it's based on a safe harbor hardship withdrawal, and sometimes it is more facts and circumstances. But in either situation, the plan sponsor has a requirement to retain documentation related to that hardship. Brandon, do you want to speak about?
Yeah, just yesterday, Bill and I see a lot of record keepers, for 401k plans who will try to sell a service to an employer where they will say, hey, look, we have this electronic option so that your participants can electronically apply for a hardship distribution or for example, a loan, a principal residence loan. And they market this as a great a tool for employers to use so that they don't have to employers can stay out of the business of deciding hardships. The problem is it is the employer or the administrator's responsibility to decide whether the hardship is permitted and to keep documentation of it. Just yesterday, April 1st, the IRS issued their periodic newsletter, and this specific topic was part of that discussion where they specifically stated that a employer or administrator cannot rely on the records of either their record keeper or the employee to justify hardships. If they audit you, they are going to want to know that you have those documents in your possession for your plan. And that is true, again, for hardships and for plan loans to the extent where they're related to a residence and we're allowing them to be financed over longer than a 5-year period.
Right. Or if any of your distributions are subject to joint survivor annuity, a lot of times spousal consent is going to be required for that. Speaking of spousal consent, that's another area where oftentimes, even if you have a TPA or someone processing your distributions for you, they're not obtaining that spousal consent. They're expecting the plan sponsor to. Finishing up on the hardship withdrawals, the common errors we see, as Brandon just mentioned, is not having the documentation, but also oftentimes your plan document is such that if a participant receives a hardship, they cannot make contributions to the plan for 6 months following that hardship, and oftentimes we see that doesn't get ceased timely. As far as forfeitures, real quickly, the plan document is going to specify the usage, how it has to be used, and also the timing of that. The IRS expects forfeitures, pretty much the balance, to go to zero at least annually. A lot of times plan documents are written that it has to be used by the end of the plan year or at a minimum the year subsequent. Also, it may say that you use it first to pay plan expenses and then secondly to reduce employer contributions. If your plan document is specific, you need to make sure you're using it in that order because it does affect participant balances if it's not done correctly. So moving on to the criteria you should consider when selecting an audit. And I'm going to be going through quite a few slides related to the DOL's audit quality study that was conducted last year and giving you some of the results of those. And you may be wondering, why is it important? You'll see that often I hate to say you get what you pay for, but there's definitely a correlation between the audit firms who don't do a lot of audits and the quality of the audit. And why it's important is the DOL, during this audit quality study, they were specifically auditing the auditors. And so they're wanting to look at the audit work papers to make sure the auditors are doing what they're supposed to be doing. And why this matters to a plan sponsor is the letter will come to you specifically. The DOL, as I mentioned earlier, it is a fiduciary responsibility to hire quality service providers. And so if for some reason your auditor's work would be deemed deficient, then your 5,500 would be rejected, and so that really matters.
And I'll give you just a couple of examples from this last year that we had in our group. Client hires an auditor, and the auditor's a CPA, and they think that because they have a CPA, the auditor, that this person is qualified to do an audit of a retirement plan, which is an unusual animal to audit. And so they hired a CPA. They think that this happened in 2 instances this last year that I'm aware of. They think that they've got a good auditor. The DOL audits the auditor, determines that auditor did not have sufficient work papers and did not do a sufficient audit for that particular year. And in both instances, the DOL issued a letter to our client imposing a penalty on our client for $50,000 for 1 year of a deficient 5,500 and a deficient audit. Now, we're able to negotiate those penalties down, but it's what Gwen is talking about getting an auditor that knows what they're doing is really important.
Right. And, Brandon, in that situation, the DOL was auditing 2011, right?
Right.
And so that audit was deficient. Well, if you've had the same auditor audit the subsequent years, then oftentimes you have to pay for another audit firm to audit those subsequent years as well. And I believe that was negotiated in terms of doing that settlement with the Department of Labor, that you voluntarily corrected other audits that you deemed to be deficient. So some of the things you may want to be considering, and the AICPA has an audit quality center, an employee benefit plan audit quality center, and on that there is some information, the importance of hiring a quality auditor. You can download it just from the website directly. And some of the things they think that you should be considering when you're evaluating whether or not to hire an auditor is to look at their qualifications first. How many plans do they audit? Employee benefit plans are very specialized and very unique, and so you want your auditor to have specific technical training that relates directly to employee benefit plans. It's one of those things, the more you do, the more of an expert you become at it, that type of thing. And you'll see from the results how that impacts it. Also, you might want to ask, what is the focus of the employee benefit plan practice with that CPA firm? I mean, who is the team that would be doing that? Do they do a lot of these audits? Or in some situations, you may have one company or an audit firm that audits your corporate financial statements, and that same team may audit your benefit plan, but that might be the only benefit plan audit they do. So that's what the DOL is kind of looking at in terms of that. So in terms of the penalties, and as Brandon said, we have seen the penalties be substantial, $1,100 per day if your 5,500 is rejected, up to $50,000. So the next slide shows some additional penalties that the DOL can assess to plan sponsors. In addition to your fiduciary responsibility of having your auditor, there's also certain disclosure requirements that go to participants, like the summary plan description and the summary of material modification. If you're not providing those documents to your participants timely, there can also be penalties assessed with that. All right, so related to the DOL initiatives, I'm going to talk a little bit about the Office of Chief Accountants. Basically, the DOL has two divisions that impact retirement plans and health and welfare plans. One is the Office of Chief Accountant, and as Brandon mentioned earlier, their focus is the auditor. They're basically auditing the auditor when they're looking at work papers. They have other initiatives that we'll cover, and then in a little bit, Bill's going to talk about the Office of Enforcement and some of the things that they are looking at. So EBSA, they're really looking at audit quality, and we'll go over some of that in a little bit, the study that they just did last year. But some of the other things they focus on is emerging issues within benefit plans. They're still focused on uncashed checks, basically outstanding checks, and those are still plan assets. Where are those participants, and what are you doing to find lost participants? As well as they're going to be giving some expanded information on fee disclosures. Y'all may recall a couple years ago the fee disclosure requirements that came out. Revenue sharing is also an issue they're still focused on related to that. As far as reporting compliance requirements, as we mentioned, they're doing cross-checks related to a retirement plan 5,500 and where's your health and welfare 5,500. If you have over 100 participants in your health and welfare plan, you need to be filing 5,500s for those as well. Another initiative they're focusing on this year is they mentioned there are quite a few 5,500s that have been filed, and the question related to whether or not the plan sponsor had a fidelity bond was marked no. It is an ERISA requirement to have a fidelity bond, and so that is something they're going to be sending letters out to ask about. Also, they had over 1,000 5,500s filed that did not have audit reports attached, and so they're going to be looking at that as well. So I've mentioned previously the audit quality study that the DOL did. What they're finding is that audit quality overall remains problematic. The deficiency rates are at an unacceptable level, and we'll talk about some of those results. They definitely see a correlation between firms with large employee benefit plan practices tend to meet the professional standards, and by a large EBP practice, they're talking about that those that audit over 100 plans, and those with limited employee benefit plan audits tend to have a higher rate of deficient work. So a little bit of preview, there's about 8,300 plan audits performed and about 7,400 audit firms that are performing those audits. The next slide here gives you kind of just a glimpse, high level. About 50% of the plan auditors, so of the 7,400 auditors, about 50% of them only audit one or two benefit plans. Contrary to that, about 1% of the plan auditors, or about 74 firms, audit more than 100. So you can see that's quite a vast difference there. So when the DOL started this audit quality study, they put into a strata. Actually, let's go to the next slide. Okay, there's a strata that they separated it out to look at, and they divided all the auditors up depending on how many plans they did, and they selected a sample from each one of these. There are, I'm sorry, I got out of line here, if you don't mind going back one. So again, it was a nationwide study, and they were coming up with a baseline. So they selected 400 plan audits to audit on that strata that I just explained to you. And the results of that were very unsatisfactory from what the DOL is saying. There was approximately, of the strata that had 1 to 2 plans, there was 76% of the audit firms who did 1 to 2 plans that were deemed deficient. And in order for the DOL to reject the audit, it was considered deficient if it had more than 5 deficiencies, which would mean there were areas of work that they would expect the auditor to perform that was not done. For the 3 to 5 and 6 to 24 plans, it was about 67% were deemed deficient. Between 25 and 99, it was about 40% deficient. For those plans that had over 100, the deficiency rate was less than, it was about 12%. So you can see there the correlation that the firms that audited more benefit plans had the lower deficiency rates. One thing that was very concerning to the department is in the firms that about 90% of the firms that they deemed the audits were deficient, these firms actually received a clean opinion from their peer reviewers. And so that is something that is going to be being evaluated by the AICPA and also the Department of Labor, that question of why did the peer review process not identify substandard work when the DOL did. And I think one of the biggest reasons is the department really expects the auditors to test areas that are more compliance related, like, eligibility, contributions, loans, the things we were just talking about related to vesting, and do you have the proper documentation and what kind of controls are in place. So those are definitely something to think about. So when you're looking at selecting an auditor, you want to look for an audit firm that has extensive experience related to employee benefit plan audits. The results of the DOL study is going to be on the DOL's website. The firms that were deemed to have substandard work, there have been 131 referrals to the AICPA's Ethics Division, and also they have been referrals made to the State Board of Accountancy. And so what we're seeing is that the auditors who don't audit a lot of these, who really just don't have the resources to invest in the training and expertise and don't really want to devote the time to become experts in this area, they're just getting out of doing employee benefit plan audits altogether and just saying, we're just not going to do these. And something the DOL communicated at a conference I was at is even if you do a lot of employee benefit plan audits, there's various types of retirement plans and health and welfare plans. So if you have 401k plans, you have multi-employer plans, multiple employer plans, 11Ks, ESOPs, you have a lot of different types. And if you don't do a lot of plans for that specific type, then that may not be an area that you are considered an expert in, and they're recommending that if you don't do a lot of them, then you should probably defer to people who do.
Thank you, Gwen, and that was good. Now I'm going to switch gears, and I'm going to discuss the DOL initiatives. Now this is from the EPSA, and that's Employee Benefit Security Administration. They are the agency that has the enforcement authority over health and welfare plans and pension plans. Now, since 2013, and again, especially in our region, which is Oklahoma, Texas, Arkansas, Kansas, and New Mexico, we have a very active DOL agency. Now, my comments about the DOL and working with them out of Dallas, number one, I think they're very professional. I think they do a very good job on their audits. These audits are a little bit different. I spent most of my career dealing with IRS audits. I think the purpose of an IRS audit truly is to generate revenue, where they're trying to, the mentality of an IRS agent is to collect revenue. I believe the objective of the Department of Labor, especially out of the Dallas region, is number one, protect the plan participants. The number two is actually help the plan sponsors, information gathering, information on how they should better operate their plan. So when you get this letter in the mail, and again, I'm going to talk about the letter, it's going to tell you that you're going to have an audit in 2 to 3 weeks, well, you need to take that seriously. Let's talk about the four areas that the DOL is focusing on out of Dallas. MEWAs, multiple employer welfare arrangements. Well, what's a MEWA? That's 2 or more unrelated employers that sponsor a health and welfare plan. Generally, these are going to be self-insured plans, and there's been a lot of abuse in this area where promoters have gone to various small employers and said, listen, I can get you a better deal if we get 25 small employers that come together in a single health plan and we pool our risks. Well, that sounds great. But the problem is a number of these promoters never had the intention of ever paying any claims. And I've been involved with some litigation, actually quite a bit of litigation in this area, and it's really a sad thing. And another thing with the MEWAs is they're focusing on employee leasing agencies. A lot of employee leasing agencies sponsor one health plan for all of their sponsors. And they state, well, I'm a co-employer. As a co-employer, I'm going to treat this as a single employer plan. And I don't have to file what's known as an M1, and I don't have to meet the state licensing requirements or the capital requirements. Because in the state of Oklahoma, there's only 11 approved MEWAs. You have to get a license. It's a very difficult process. Plus, you have to put up capital. The minimum capital in the state of Oklahoma is $500,000. And if you have any type of significant MEWA, you could be looking at putting up millions of dollars. And also with the MEWAs, you have to file the Form M1. If you don't file the Form M1, it's a $1,000 a day penalty. There's no correction arm if you fail to file your M1, and there's no statute of limitations.
Hey, Bill, why don't you mention to our clients there, folks that accidentally have MEWAs?
Oh, good point. Good point. We have a lot of what I call related employers who, well, for retirement plan purposes, they may be treating their retirement plan as one large single employer. And
under common control.
Under common control, and they're using what's known as the affiliated service group rules. Mm-hmm. In a MEWA, you can't use an affiliated service group. For example, we have a lot of private equity companies. I have one general partner that sponsors the plan, and they may have 15 different companies under their holding company. But in order to be a single employer and not be deemed a MEWA, you're generally looking at a parent-subsidiary relationship of at least 80% common ownership. And let's say I'm the general partner and I have my same partners throughout ownership of these 15 companies, and that only adds up to be 60%, because I'm always selling a small piece to an outside vendor for the other 30 or 40%. That's not a control group, and you have a MEWA. And we run across that all the time.
Another scenario we see is when we have health plans that have independent contractors that they allow to participate. And so it's it's easy for employers that are operating a health plan, and maybe we let Bill and Gwen and Brandon, who are independent contractors, participate in that health plan. Well, they're not employees. That is also an accidental MEWA.
Absolutely. Great point, Brandon.
That's awesome.
The other initiative is the Fiduciary Service Provider Compensation Project. Basically, they're looking at revenue sharing, fees paid to brokers and fiduciaries. That's a large initiative. And the third thing is the Health Benefits Security Project. Well, that's basically auditing health and welfare plans. Mm-hmm. In the past, in my 25 years that I've been working with DOL audits, it's been very rare to have a health plan audit. Normally, it had to do something when a company went bankrupt and they didn't pay the claims, very rare. But now these audits are focusing in on basically compliance with the Affordable Care Act. ESOPs. ESOPs continue to be a problem in this region, and we're seeing a lot of activity. We work with a lot of sponsors that have ESOPs, and I would say in the last 3 years, about 30%, 40% of these clients have gone through audits. And again, what are they looking for in ESOPs? Number one, there are a lot of problems with S-corporation ESOPs, with not complying with the non-allocation rules, not complying with the UBIT requirements, not calculating cost basis correctly, and the most common problem is not having adequate valuations. For example, a lot of small companies, strong companies, have ESOPs. Well, they go to their auditor or they go to some outside consultant who doesn't do a lot of valuations, and they're just not credible. So, again, if you have a valuation that's not credible and you have you can get back into those problems of not having an adequate audit.
Yeah, exactly.
I'm going to go through a few of these, but I'm going to deviate from the slides just because I've come off 2 major DOL audits, and I got another one that's starting. I'm going to concentrate on the actual checklist that they're using for health and welfare plans, and then after I go through the checklist, I'm going to go through a series of questions that they've been asking employer sponsors. Okay? But again, Office of Enforcement, this is EPSA, and if you live in those states of Oklahoma, Arkansas, Texas, Kansas, and New Mexico, that's the group that will be auditing you out of Dallas. What are the issues that they're looking at? Well, the DOL, they're looking at, again, lost participants. It continues to be a problem. Are you cashing out those participants that have balances under $5,000? Uncashed benefit payments, and this is something Gwen actually brought to my attention about 3 years ago on an audit that I was working with her, and they were like, well, what about the uncashed checks? I'm like, what about the uncashed checks?
It's still plan assets.
That was news to me, because if you have uncashed checks, well, a lot of times the custodians, the large financial institutions, they're putting those in their own general account, and they're not showing up under the plan.
That's right.
As uncashed checks.
Right.
They're getting better about that.
Right. Another thing where we see this becomes an issue is when a plan is terminating, and you're seeing that all the assets have to be distributed out of the plan. It has to have a zero balance. One question you should be asking yourself is, have there been distributions that have been made out of the plan, but the check was actually never cashed? Right.
ERISA spending accounts are very, very popular today. That's where the revenue sharing, where excess revenue sharing is held in a suspense account, and the plan sponsor can use that to pay for legal fees, accounting fees, and at the end of the year, if you haven't used that spending account, what do you do with it? Do you allocate it back to the participants? Assessing valuation of hard-to-value assets, again, we find this in our very small plans, where someone's invested in a limited partnership, real estate, other assets where they're not getting an annual valuation on those assets.
Or if you have a self-directed brokerage account, sometimes you'll end up with some hard-to-value assets in there. Normally it's not significant, but it's something that you need to be concerned about.
I'm going to talk about the DOL audit triggers, and then I'm going to deviate from the slides because of time and get into my checklist. The DOL audit triggers, number one, random selection. Most of the audits on the health and welfare plans that we see are random. Now, the MEWAs are not random, and the ESOPs are not random. Or someone has actually complained. Or you filed your 5500 late, and you continuously file your 5500 late. Or you check on your 5500 that the withholding has been late. I'm going to deviate from the slides, and I want to go to the actual attachment that you will receive in the mail if your health and welfare plan is going to be audited.
And this is the copy of the document that we've made available on our website for
Right.
you folks listening.
Right. This is the standard checklist. And when you get this letter in the mail, and generally you're going to have 2, maybe 3 weeks to prepare, don't wait 4 days or 3 days before the audit starts. I've done, I don't know how many I've done in the last couple of years, but the last couple that I've done, both employers state that they have spent a minimum of 40 hours gathering documents and talking to their service providers. Now, I've had associates in my office help gather this information, and they've also spent 10 to 15 of their own hours trying to get ready for the audit. So let's go through the checklist really quickly, and I'm going to make highlights of some really important items. Number one is your plan document. Now, if you're a fully insured plan, you think that's easy? Well, a number of our providers, and I'll just pick on them, Blue Cross, United Healthcare, others, they may be a whole year behind in getting their document done, and that's an ongoing problem. So make sure you have the document and it's been signed. I'm going to go to number 3. Number 3 is a very, very important item. You're going to have to go, again, a lot of my clients don't have their contracts, they don't have their documents, they don't have the service agreements. You're going to have to go to all of those providers, and you're going to have them provide you with that information. Let's skip down to number 6. I know this is a difficult one. It has to do with the certificates of credible coverage. Even though we don't have to provide those after 2014, the DOL still wants to go all the way back to 2010. They want to make sure that the certificates have actually been provided and that we haven't excluded any claims for pre-existing conditions. Okay? You're going to have to get on this one early, because if you're getting these from your insurance carrier, they say they don't have them, they don't keep them. That's too bad. They're going to have to provide you those documents. You'll spend almost 2 or 3 weeks calling them and writing them to get these certificates gathered.
Bill, can I add something?
Yes.
One thing also to consider is when you change service providers and having to go back to a former service provider. So it's a good thing to know what's on this checklist and make sure you have it in your records.
Right. Go to J on page 4.
I'm sorry.
I'm going to J on page 4, and it says a copy of the written appeal procedures established by the plan. Well, that sounds pretty easy, but let me tell you what they're going to be asking for. You're going to pull out of your document the standard appeals procedure from the Affordable Care Act, the updated procedures, but when they come to do the audit, they're going to ask you for a list of denied claims, and they're going to pull a certain percentage of denied claims from your insurance carrier or your TPA, and they're going to audit those claims. There's been a lot of problems with the insurance carriers denying claims, and they're following up on that. And Gwen, I think you had a comment on that and that you've had some issues.
Right. One of the comments made by the DOL investigator was that, Ian Dingwall from the Department of Labor, is that this is an area that they're viewing as abuse because initially claims are being denied and there is an appeals process, but the ratio of the amount of claims being denied versus those that are being appealed is giving rise to them thinking that this is an abusive situation.
Right. Brandon just made a good comment. Some of you may not have downloaded this, so I'll read to you as I skip through here. Going to number 12. And number 12, they want the materials describing any wellness program or disease management program. Well, we have a lot of clients who have drafted their own smoking cessation program. And with the DOL and the HIPAA requirements, they're very, very strict requirements on what you need to have on a program where you're charging a surcharge if you are a smoker or if you have a BMI in excess of a certain weight. And if you haven't gone through the procedures or provided the alternative means of meeting those goals, or you've charged in excess of the past requirements in 2010, you could only have a 30% surcharge. Now we can have a 50% surcharge. You're going to be out of compliance. And again, when you're out of compliance with the Affordable Care Act, it's a $100 a day penalty.
Bill, do you recommend for folks to have their wellness policies incorporated into their actual health plan document?
Actually, no. I like to do the wellness policy as a separate document because you're updating this plan document all the time. You may not be giving that document out on a timely basis because it's taking the provider so long to get the documents done. And it's very important that the employees understand what's in the wellness policy, and that should be done separately as an appendix to the health plan.
And the only thing I would add to what Bill is saying there is if you have a wellness, I asked the question for a reason. If you have the wellness policy separate from your actual plan document, you need to incorporate it somehow into your plan, either as an appendix or it needs to reference that it's part of your health plan. And the reason is there are state law requirements that might prohibit, for example, a smoking cessation program, but those are preempted by ERISA if your wellness program is part of your health plan document.
Right. And we're running out of time, so I'm going to move to 14. 14 deals with proving that you are a grandfathered plan. And you're going to have to provide information all the way back to 2010 that you have not made changes in the plan that would make you lose grandfather status, and there's a list of those, and it's very, very detailed. The problem is I have a lot of clients who don't have their documents back from 2010. So, again, you're going to have to start early so you can get those documents. I'm going to page 17. MEWAs are on the checklist. If you have a MEWA, you're going to have to provide a lot of information describing how this MEWA works, if it's funded, if you're exempt from the state filing requirements. Number 18, they want to look at lag reports. There's been a lot of complaints that the fully insured carriers are sitting on claims and not paying claims on a timely basis. That's not your fault, but you're going to have to get these reports. Again, it can take a full 2 to 3 weeks to get the lag reports. So you've got to get on this immediately. Number 19, 19 is the hard one. On 19, they want all your plan records. And if you're a health and welfare plan, I got it circled. They want your canceled checks all the way back from 2010. So if you're a large plan and you're paying thousands of claims, you got to show up that day with thousands of cash checks. Number 21, 5,500, and again, we show up. We don't do a lot of work with a client. May not know them very well. We go, well, where's your 5,500? And they're like, well, this is a health plan. We don't file a 5,500. Oh, that's a problem. So, 24, they want a copy of the fidelity bond. The fidelity bond, we see a lot of problems. The fidelity bond has to be in the name of the plan. Mm-hmm. Now, I'm going to quickly go through. These are the questions that you're going to be asked in a DOL audit. Number one, they're going to ask that a plan fiduciary be present for the audit. Now, if you hire me to be there to represent you, I cannot speak during this presentation and during this interview, okay? Just want to let you know. But they're going to ask you, the fiduciary, name, title, education, what type of ERISA training have you received, what is the definition of a fiduciary, are you a fiduciary? They want to know, are you familiar with HIPAA? Have you read your HIPAA policies and procedures? Who's responsible for HIPAA? Do you review the Form 5500? You signed it. Are you telling me you don't know what's in it? Have you reviewed the audit report? Why not? How do you select service providers? What's the qualification? Have you done a formal request for a proposal? How often do you select your service providers? That's your TPA. That's your auditors. That's your attorney. And does your attorney have the qualifications to represent an ERISA plan? Have you read the plan documents? Here's the big one. Walk me through the claims process. If someone has a denied claim, and this has been tripped up the last couple of weeks because I didn't know this was coming, but next time we'll be prepared. I don't know how many of you out there listening actually understand the process from submission of a claim, the appeals process, and how long it takes to process that claim. When's medical review allowed? And I'm going through here. What's the time frame for submitting and paying a claim? And discuss the special enrollment rights. Have you distributed the SBC? And do you even know what an SBC is? I mean, this is pretty tough on, an employer, because normally you're going to have a high-ranking officer be the fiduciary who sits in, and it's been pretty rough on the last two because I wasn't aware of these new questions. But take note because you need to be ready for that.
Great job, Bill. The one last thing I'll add to that is we do find it helpful, and this is not just a plug for work, but we do find it helpful to actually be present and to kind of serve as an intermediary with our client and the DOL, because a lot of times they can be a little intimidating, especially for an HR person who's dealing with them.
Yeah.
So it's just a suggestion. Lastly, and Brad will close us out, but I want to mention Gwen's contact information is in our materials here, and feel free to reach out to Bill and I, of course, but also Gwen if you have questions about today's presentation.
I want to thank attorneys Brandon Long and Bill Freudenrich and special guest Gwen Bryant with HoganTaylor for presenting today's webinar. And on behalf of the law firm of McAfee Taft, thank you for joining us for another Employer Link webinar, and have a great afternoon.